Well, good morning, everyone. Welcome to Sheehan Finney's reboot of our annual employment law seminar, part two, on this cold November morning. Quite a difference from the warm May days that we have at our annual seminar, but hopefully we'll be back to in-person meetings in the very near future. In the meantime, part two, the reboot of our labor and employment seminar. We had part one in October a few weeks ago, and I'm thrilled that we have our presenters today to talk about some important topics that you folks will be facing, especially as we close out this year and look into the next. I'm thrilled that we have over 450 people registered for our seminar today, and that's terrific. We really appreciate that. We appreciate you taking the time to be with us. A few housekeeping matters, if you don't mind, as we get started. First of all, that this session is going to be recorded. Audio and the slides will be available on our website following this seminar. For HRCI credits, they are available. The information on that is available on the final slide today. And if you've got questions, and you will have questions throughout the presentations, there's a tab at the bottom, and just type in your question, and our presenters will do their very best to answer those during the session, and if they've got time afterwards as well. Time is important, so we know that your time is precious. Our program is scheduled to end somewhere around 9:30, 9:45. The last 15 minutes or so will be set aside for questions and the answers from our presenters. So our presenters, I'm thrilled that we've got Liz Bailey, Megan Carrier, and Brian Bouchard here today. Liz is a litigator, a trial lawyer by training, but she represents employers of all types and sizes. By the way, the bios for each of our presenters are available on our website, and I recommend that you go there and look them over. But in the meantime, Liz is a litigator, a trial lawyer with experience representing both public and private sector employers. She's got a particular expertise in working in public sector employers, representing them in all manner of union negotiations, arbitrations, and the like. And in recent years, she's really specialized in internal investigations. Megan is a litigator. Oh, and Liz, by the way, her topic is covering layoffs, reductions in force, and other matters. The high season for those, as you all know, is really November through January, but COVID has changed things a bit too, so it could be throughout the year. So it's an important topic for sure. Megan, also a litigator, is by training and has great experience before state and federal courts, and has spent a lot of time working on employment matters. And her specialty too has been the area dealing with retaliation claims. As we know, retaliation claims used to be an attendant claim with regard to discrimination claims. Now they are, in many regards, a standalone claim, whistleblowers and the like. And we're seeing now the first and second wave of COVID-related retaliation claims. And we wind up today's program with Brian Bouchard, our newest shareholder. Brian was elected into the partnership last month. And Brian is a litigator also, but with extensive experience in employment matters. Brian's going to be here to talk about today the Payroll Protection Program, PPP, under the CARES Act, and the Family First, FFCRA. Both are set to expire at the end of the year, but there are lots of issues associated with that and related matters as well. So without further ado, I'm going to turn the program over to Liz. Thank you so much for being here, and enjoy the program.
Thank you, Jim. My topic today, and Andrea, if we could have the next slide. My topic today is the proper handling of layoffs and reductions in force. And as Jim said, many times there seems to be an uptick in that at the end of the year. My great hope for you all is that this is just an academic exercise and you don't need to take these concepts into account anytime soon. But next slide, please. My agenda today is just to go through some concepts that you might want to be thinking about if you find yourself analyzing whether you need to do a layoff or a reduction in force. I'm going to talk about some options other than layoffs, something that you ought to be thinking about on the front end of all of this. Notice considerations that may or may not apply, selection criteria to think about with layoffs, any collective bargaining agreement or employment contract requirements you might have that are applicable to you, severance packages and concepts related to them, the payment of final wages and coordination of benefits, as well as follow-up interactions, which can be very critical in these situations. Next slide, please. So a starting point before you do a layoff is to really ask yourself some very tough questions and determine if a layoff is actually what is necessary under the circumstances. I think most employers would do that almost automatically because nobody wants to do a layoff. But it's a very good idea to really sit down and figure out if there are options available to you short of layoff that may get you where you need to go as an employer to meet your fiscal needs. One thing I'll say at the outset of my presentation is that these concepts of layoffs and what you need to do to navigate them, there's a lot of pitfalls that you could meet along the way. And it is a great opportunity to work with your in-house counsel or work with your outside counsel before you implement anything, before you implement a layoff or set any communications out about a layoff. Because by brainstorming, by having that confidential analysis, it really can help in avoid some legal challenges down the road. So one thing to think about in general is, do you really need a layoff? Is there something that you can be doing short of it that will get you where you need to go? There are concepts that you may be very obvious, but reduction in hours of employees rather than laying them off, reduction in pay, and any advance notice requirements that might exist. And in part one of our series, Mark Ventola had talked about in his wage and hour section, concepts that are important to wage and hour issues, including reductions in pay. And to be bearing in mind if you're going to be reducing somebody's pay or changing their hours of work, what written notice is required in advance. And certainly you can't be doing something midstream. You can't change the rules of engagement on what somebody gets paid for their hours of work in the middle of a pay period. So if you're going to be contemplating those types of changes instead of a layoff, bear in mind what your state requirements are for written advance notice requirements about changes in pay. The other thing to be thinking about are concepts of partial unemployment, or perhaps your state work share programs. One option may be if you're reducing employees' hours, that they have the ability to get some level of partial unemployment through your state unemployment system. Usually what would happen is unemployment is triggered because they're not fired, but they have a partial reduction in their hours. And you would need to look at your individual state systems to see how that amount of unemployment would interplay with the amount that you are still paying the employees to work. There would be an offset going on so that they wouldn't get full unemployment, but you could determine how much unemployment they should be able to receive if you would reduce their hours. Another great option to look into is the availability of your state's work share programs. Those programs in general, they can vary from state to state, but in general, they give you a great opportunity as an employer to keep your employees working with reduced hours and get some level of partial unemployment like we discussed. But the difference is that you go through an application process with the state, you get qualified to participate in this program, and it can be a real win-win situation because in some instances, those unemployment benefits are not counted against your account as an employer. Something very much worth looking into before you would institute a layoff. The benefit, obviously, of having these options in play versus a layoff is that you keep your employees. They stay with you. They're getting some level of pay from you. And if economic times get better for you, you are better positioned to pivot and get back ramped up and back on track versus having to go back and recall people or rehire new employees altogether and the added expenses of training. Next slide, please. So if you considered those options and you still think, unfortunately, a layoff is necessary, The next thing to do is verify whether or not you are subject to the federal WARN Act or to any state mini WARN Acts, which would require you to provide certain notice to employees in advance of a layoff. The WARN Act applies in general to larger employers with 100 or more full-time employees. There is a 60 calendar day notice requirement in advance of a plant closing and mass layoff. And those terms are in quotes because they are defined terms under the WARN Act. There are requirements about what the notice must contain and to who the notice must go. And one thing I'll say is that a lot of our employment laws are very lengthy, very tough to read. The regulations are very dense. The WARN Act is a complicated law, which is why I said at the outset, these layoff situations really are critical situations for you to involve your legal counsel, but it's not a long statute. And the regulations pertaining to it are great roadmaps to a lot of the questions that you might have about whether or not you're subject to WARN. And in addition, there is a lot of great material on the US DOL website about WARN resources and guidance materials. So that information is available to you and should really be looked at very closely. The regulations give very detailed examples about what the notice needs to contain and to who it goes. There may be some exceptions to the WARN Act that are worth verifying. There are 3 exceptions in general: altering business, natural disasters, and essentially exception for unforeseen business circumstances. That last one, the unforeseen business circumstances, is something that was really in play a great deal when we were seeing layoffs in the beginning of the pandemic. But something to bear in mind, those exceptions, when you look at the regulations, they do provide you an exception from the 60-day calendar day notice period, but they don't provide an exemption from providing notice in general. You do have to provide notice just as soon as practicable. And lastly, under WARN, there are time periods that are in play that you need to look at very carefully. So look at whether or not your various series of layoffs, even though one layoff might not in and of itself trigger WARN, you anticipate a series of layoffs which cumulatively would trigger WARN requirements. And when you look at the statute, in addition to the 100 or more employee criteria, there are also criteria built into the definition of plant closing and mass layoffs, which require you to count employees and have a specific number of employees that are impacted by the layoff involving a plant closing or a mass layoff. Something to look at very closely in advance of any layoff. Also look, as I said, at your mini WARN Act by state, because the state laws, to the extent that they exist, could have briefer time for more strict time frames for providing notice, or also different employee numbers that would subject you to those state law requirements. Next slide, please. The next thing I think to think about when you are doing a layoff is thinking carefully about what your selection criteria are. It's important to be organized and to have an organized thought process about that and identify what are your legitimate business reasons for selecting the group that you have selected. They could be very basic, obvious reasons. You've lost the contract and the employees who were working on the contract are people that unfortunately you need to lay off. It may be that you've lost a particular line of business and a whole department needs to get shut down. It may be that you are focusing on not just a department, but a corporate-wide layoff. It will be very important, and it comes up again in another context about severance packages, to understand who it is that you've selected and why that makes sense. And then to work within that selection group as to further define who is included in the layoff. It's also important with your legal counsel to look at, once you've kind of figured out where the layoff needs to be targeted, what do those demographics look like? when you take into account your preliminary list of who would be impacted by the layoff and who would not, what does that look like in terms of various protected classes such as age, gender, race, color, national origin, other protected statuses? And sometimes it is really surprising when you look at that information that, to your amazement, it looks really skewed. That's why it's good to be having these confidential analysis done with attorney-client protection if you can, so that you can work through these issues and understand if there is a potential disparate impact. That is, you were doing something neutrally, but as it turned out, when you looked at how it looked like you had a greater impact on one or more protected groups than another. There may be very good reasons for that, but it's just good to know and to think about before you implement a layoff. And lastly, you're going to want to document the application of that selection criteria. How did you determine who should be in the layoff, what the group should be, and why? Next slide, please. The other thing to be thinking about, and this doesn't apply to everybody, would be, do you have any collective bargaining agreement or individual employment contract requirements that come into play if you're having a layoff? As you may know, a lot of states are not heavily privately unionized at this point, but you still could be subject to one or more collective bargaining agreements. It's really imperative that you refresh yourself about the requirements in those agreements and any amendments to them, any memorandums of understanding that may impact layoff and recall for that matter. Many collective bargaining agreements have very detailed protocol for how you may lay off people, any notice requirements that must be given, and who will be selected. A lot of times it goes by reverse seniority. So it's important to understand that, because you don't want to be caught short that you're violating your own collective bargaining agreement just because you hadn't really given it as much thought as you should have in planning your layoff. The other criteria that you often see in CBAs is recall rights. So a good guideline for you, if times get better, how you go about and recall various individuals and how long those recall rights exist. Lastly, there may be some people that are subject to employment contract restrictions. That might be infrequent, but it's important to look and see for the individuals that you're thinking of including in a layoff, do they have individual employment contracts in any way that would somehow restrict your ability to include them in the layoff, or may have some other impact that you just didn't have in mind. Next slide. Severance packages. Many times it is customary when you have a layoff for the employer to offer some form of a severance package program in connection with the layoff. There may or may not be state requirements on point that would require you to do that. But in general, if you are thinking of doing that as a nice professional way of recognizing this is a hard time for people who are impacted and you're trying to soften the blow a little bit, you would want to think of what your severance package is going to look like well in advance. And again, work with your counsel about crafting it, because it will contain a lot of specific legalese. So one important thing about a severance package is you're going to be verifying that if you're paying somebody extra than what you are otherwise owe them for final pay, that it's very clear that that payment is in fact extra from anything that is owed. Most severance packages, if an employer is going to be giving an employee, laid off employee, some money they're not otherwise entitled to, it's very common for the employer in exchange to get a general release of claims from the employee. That's very sound practice, because the idea is you want to buy peace, essentially. You want everybody to walk away from the relationship, essentially not worried about further litigation down the road. So that a release of claims is obviously a very significant language, and it may be tailored to not only federal law, but also your state law. which applies to the employee in question. So that will be critical to have reviewed by council. The other thing to be thinking about in a severance package is making clear, if you have an agreement that you are providing to the employee, that you are also making clear about what existing contractual agreements still survive. There may be some restricted, what we call restricted covenant obligations, like non-disclosure or like non-solicitation. So making sure that whether or not the employee accepts the severance package, they are mindful that these obligations will continue when they leave the company. And lastly, in connection with a severance package, if you have a release, if you have an employer of 20 or more employees, then you will be subject to some federal law concerning age discrimination, the Age Discrimination in Employment Act. That's been amended by the Older Worker Benefit Protection Act. And that in turn will require you to have very specific language in your severance agreement that addresses the release of claims related to age discrimination. It will contain a consideration period of 45 days, and it will allow a 7-day revocation period for the employee to revoke his or her acceptance of the agreement. It will also contain some other requirements that need to be included in the language of the severance package. Something to be mindful of. Many of you are familiar with this concept in relation to individual departures from companies where there's a 21-day consideration period. Just bear in mind, this is a more extensive consideration period because of the fact that it does involve a layoff. Also, you would need to be providing some required language under this act to employees affected by the program concerning the positions and the ages of people who are included in the program and who are not selected for layoff, and an explanation of what the decisional unit had been. I recognize that's some dense language, but it is something that you just need to bear in mind and work with counsel on as you craft your severance packages. Next slide, please. Also be thinking of very basic things such as the payment of final wages. Obviously, when you're doing a layoff, that becomes a more cumbersome task than if you are letting one person go. But it's very important to be thinking ahead, being mindful of the fact that if we're going to be paying final wages, what are they? What is owed under our applicable state law? And making sure that they are paid in a timely manner and not just in the next regular pay period. Also be looking, as I said, at whether we, under our policies as an employer or under applicable state law, we need to pay the employee anything other than paying for the last week they worked, which is perhaps unused PTO or sick leave or vacation. So if you have a multi-state situation, it may be that you have different obligations from state to state, just to bear that in mind. Next slide, please. Also be thinking about the coordination of benefits as the layoffs unfold. You will presumably be working closely with your benefits broker about providing any COBRA information to employees, working with them to make a smooth process for their continuation of coverage, and also working with them to do the best you can to have a smooth transition about any available unemployment benefits. The requirements will be different from state to state, but it's just a great idea to be thinking about this ahead, thinking about what you can do in your infrastructure to understand that when these layoffs occur, there's probably going to be a real uptick with people applying for unemployment benefits. What are you doing internally to make sure that you are able to quickly adjust for these unemployment benefits, quickly respond, make sure that your employees are not, waiting on your end, or that the process isn't being delayed because you're taking, longer than needed to respond to unemployment benefit outreach efforts from your state agencies. Next slide. And lastly, talking a little bit about follow-up interactions. This might seem like a very basic thing, but actually, I think when we see people being upset, people feeling like they need to go to state agencies, a lot of times it starts with the fact that they've been let go and they are feeling like they're being ignored and that they have real questions that they feel they need answered and they're not getting answers that they want or need. So it's a great idea to be thinking in advance about how are we going to be available, be responsive to our employees who are laid off when they need to reach out to us. There may be issues about people returning severance packages. People may have questions. But even if you didn't have a severance package and somebody is let go, you may feel as an employer like, look, we talked about this. We provided them with information at the time. I feel like we've done a really good job at communicating with this employee about what to expect. But for some reason, the employee still has questions. It's great to let them know in writing various points of contact for various issues so that they can reach out and to have a system where it is given a high priority for a response. People do feel frustrated. They feel like they don't know the answer to something. And if they feel ignored, it is not uncommon for them to reach out to a state agency because they feel like something is going on that they don't understand. And that's not something that you want to have happen as an employer. You want to be responsive and you want to try to get answers and get issues resolved as soon as possible. And lastly, not be losing sight of any recall opportunities. It may be that you are able to recall employees. You're going to want to have a plan in place about a communication system if you anticipate that will be the case. So those are some basic considerations about layoffs and reductions in force. I'm happy to answer questions at the end of our presentation, and I turn this over to Megan Carrier.
Good morning, everyone, and thank you, Liz. My topic this morning relates to one of the many new challenges employers are facing as a result of the pandemic, and that is the increased risk of whistleblower and retaliation claims from employees who allege that they were disciplined or discharged either for expressing health or safety concerns relating to the virus or for requesting accommodations like remote work arrangements. So what I'd like to do in the time I have with you today is to briefly go over the nuts and bolts of retaliation and whistleblower claims, which I am hopeful will be familiar to most of you, so it will be a nice refresher. And then give you some information about the specific types of retaliation and whistleblower claims we've been seeing in connection with the pandemic so that you can take some steps to avoid those going forward. So starting with the basics, what is retaliation? I'm sure many of you have this memorized, but retaliation is a materially adverse action that's taken because an applicant or employee engages in an activity that's protected under the law. A number of laws contain anti-retaliation provisions, including Title VII, the ADEA, the ADA, the FMLA, and state anti-discrimination laws. So why do we worry about retaliation claims? We worry about them mainly because they are very popular. Since 2009, retaliation has been the most commonly alleged claim with the EEOC. Back in 1997, approximately 23% of claims filed with the EEOC included retaliation. And in 2019, that number was just under 58%. So as you can see from this slide, even where the total number of claims received by the EEOC appears to have declined slightly, the number of retaliation claims has continued to steadily increase. Another reason we worry about retaliation claims is that they're typically pretty intensely fact-based, which means that it's difficult to get rid of them with, say, a motion to dismiss or a motion for summary judgment. As a result, retaliation claims can live on even after the underlying claim, like a claim for discrimination, fails. So how does a claimant prove retaliation? There are three elements: protected activity, a materially adverse action, and causation. Looking specifically at the first element, protected activity can take a few different forms. An employee engages in protected activity when he or she asserts a legally protected right, poses discrimination, or participates in a complaint process. So I'm going to go over each of these types of protected activity and give you some examples of the forms they're taking most commonly in the context of the pandemic. So what sorts of federally protected rights are employees asserting in connection with the pandemic? Most frequently, we're seeing leave requests. As I expect you all are aware, COVID spurred the passing of the Families First Coronavirus Response Act, or the FFCRA, which in addition to incorporating existing FMLA requirements included the Emergency Family and Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. Those provisions require certain employers to give employees expanded paid family and medical leave, as well as emergency paid sick leave. So based on both the original requirements of the FMLA and the expanded requirements of the FFCRA, employees are requesting leave due to things like their own illnesses, to care for sick relatives, or to care for children whose schools or daycares have closed in whole or part. COVID-19 has also resulted in increased requests for various accommodations under the ADA. If an employee is concerned about working in the office because he or she is at a higher risk of severe illness than others, or potentially the employee has been diagnosed with anxiety in connection with the pandemic, that employee does potentially have a disability that needs to be accommodated under the ADA. Accommodations under these circumstances might include extra social distancing measures in the workplace, like relocation from a cubicle to an office, a change in duties or a temporary transfer to a different position, a modified work schedule, a leave of absence, or a remote work arrangement, among others. If an employee has been granted the right to work remotely, it's important to consider that that employee might also be entitled to other accommodations. For example, if an employee has been granted a standing desk as an ADA accommodation in the office, that employee is likely also entitled to a standing desk while working remotely at home. If you're interested in more information on this accommodation issue, though, there's a lot there, and I highly recommend that you check out, if you haven't seen it already, the presentation by our colleague Karen Whitley during part 1 of this series, which is available on our website. Finally, we're also seeing employees assert their rights under the National Labor Relations Act to join together and speak out about or otherwise protest the safety of their work environment. The second type of protected activity is opposition to discrimination, which is defined as explicitly or implicitly communicating opposition to perceived discrimination. A communication can be protected opposition to discrimination, even if it doesn't include buzzwords like harassment or discrimination, but it does have to be sufficiently clear that a reasonable employer would understand it as an assertion of legal rights and to call for their protection. So looking at opposition to discrimination in connection with the pandemic, we're frequently seeing employees who have been denied a requested accommodation, for example, the ability to work remotely, complaining that the employer's denial of that request constitutes discrimination under the ADA. And it's important to remember that if you have an employee who's complaining about discrimination, those complaints constitute protected activity, even if the employee is wrong. As long as the employee has a reasonably good faith belief that discrimination has taken place, the complaint is protected, and you need to be sure that you're taking steps to avoid any kind of retaliation. An employee complaint could also take the form of a hostile work environment claim. So for example, let's say you have an employee who is working remotely as an accommodation, and that employee comes to you and says that her supervisor is really giving her a hard time about it, maybe making it difficult for her to get her job done. That should be setting off some red flags for you, because even if the supervisor's conduct hasn't really risen to the level that we would consider a hostile work environment, the employee's complaint is protected activity for purposes of a retaliation claim, as long as the supervisor's actions, if repeated enough, could rise to that level at some point in the future. Your employee does not have to wait until the conduct has actually created a hostile work environment to make a complaint and to have that complaint be protected. All of that being said, not all employee activity will be protected opposition to discrimination. Remember that the complaint has to be based on a reasonable good faith belief that the conduct opposed is unlawful or could become unlawful if repeated, and the employee has to act in a reasonable manner to oppose it. So if an employee complains that it isn't fair that she can't work remotely, but doesn't tie that allegedly unfair treatment to unlawful discrimination, that complaint likely is not protected activity. Likewise, actions that take an unreasonable form, like a protest that renders the employee ineffective for his or her job, those are not protected activity either. Finally, an employee engages in protected activity when he or she participates in a complaint process. And that broadly includes participating in an investigation, proceeding, or hearing, essentially in any way. This activity is protected even if the underlying allegation is ultimately without merit. So going back to our employee who has been denied the right to work remotely, let's say that employee files either an internal complaint or a complaint with the EEOC. Then let's say that another employee participates in that process by providing a written statement in support of the first employee's claim. Regardless of the outcome of the complaint, both of those employees have engaged in protected activity. Okay, so we are through the first element of a retaliation claim, protected activity. On we move to the second element, which is a materially adverse action. Materially adverse actions include actions that might deter a reasonable person from engaging in protected activity. An action may also be materially adverse, even if it has no tangible effect on employment or takes place exclusively outside of the workplace, as long as, again, it might dissuade a reasonable person from engaging in protected activity. So examples: failure to promote, termination, written or verbal discipline, a negative performance evaluation, and demotion. As we all know, the pandemic has presented economic challenges that have necessitated a number of adverse actions. So we're seeing employees' hours being cut, we're seeing their pay being cut, we're seeing forced leaves or furloughs, layoffs, reductions in force. All of these things are, of course, materially adverse actions. We're also seeing that following a reduction in force, the employees who are staying on with the employer might be required to take on additional duties or different duties, longer hours, and under certain circumstances, depending on the employee's situation, those could be construed as adverse actions as well. I do want to stress that this is an intensely fact-based inquiry. Context matters, so the same action might be immaterial under one set of circumstances and material under another. So for example, increasing the work hours or duties of an employee who is, because of the pandemic, taking care of a child who is out of school, that could, under certain circumstances, be spun as an adverse action, whereas another employee might actually welcome those changes. So it's really important to look at each employee's situation separately. All of that being said, an action that is nothing more than a petty slight or an annoyance or something more trivial, that won't rise to the level of a materially adverse action. The third and final element that an employee has to prove for purposes of a retaliation claim is a causal connection between the protected activity and the adverse action. In order to satisfy that element, the employee has to prove that the adverse action would not have occurred but for the protected activity. The standard doesn't require that retaliation be the sole basis for the action. There can be multiple causes, and the protected activity need only be one of them. There are two ways of proving causation: direct evidence and circumstantial evidence. Direct evidence of retaliation is a written or verbal statement that the challenged action was taken because the claimant engaged in protected activity. So for example, a manager sends an email saying, "I demoted employee so-and-so because she complained that I discriminated against her." As you might imagine, this type of evidence is thankfully relatively rare. Most often, complainants are trying to prove causation with circumstantial evidence, which falls short of being direct evidence, but nonetheless does raise an inference of retaliation. The most common types of circumstantial evidence we see are, first, temporal proximity, or a short period of time between the protected activity and the adverse action. Generally, we're talking about a pretty short time frame here. Courts have found 3 to 4 months to be insufficient, unless there's other activity that suggests an ongoing pattern of retaliation. Another type of evidence that is sometimes used as circumstantial evidence is comparative evidence. So where the employee claims that he or she was treated differently from other similarly situated employees. One common example is selective enforcement of policies. In the context of COVID, we're seeing claims that remote work policies are being enforced in a retaliatory manner. So it's important to be sure that if you do have a remote work policy, or if you are allowing some employees but not others to work from home, that you're doing that equally, and that the decision to allow an employee to work remotely is based on neutral and reasonable factors. Another potential comparative evidence trap in connection with the pandemic relates to layoffs and furloughs. Employees who are subject to one of those actions may very well claim that other similarly situated employees were allowed to continue working. So be sure that if you are in the unfortunate position of having to lay off or furlough employees, that your decisions respecting which employees will be subject to that action are based on neutral factors, and that similarly situated employees are all treated similarly to one another. Finally, employees frequently use inconsistent or shifting explanations for an adverse action as comparative evidence. This can be a problem, for example, when you have multiple people involved in a termination decision, and based on their differing interactions with the employee, they each support the decision to terminate for different reasons. So let's say you have an employee who is being separated from the company, in part because the company needs to do a COVID-related reduction in force, and in part because the employee has some documented performance concerns. If that's the case, you want all of those reasons supporting the decision to be documented in the same place so that they all come out at the same time. Otherwise, that information may filter out over time and lead to an appearance that the employer is changing its story along the way. There are lots of non-discriminatory reasons an employee might suffer an adverse action, of course. Obviously, poor work performance, maybe the employee applied for a job and just wasn't qualified for it. Maybe the employee regularly fails to show up for work or violates work policies. Or again, unfortunately common one of these days, the employer has to eliminate positions or take other actions for legitimate COVID-related business reasons. But when facing a retaliation claim, the most important thing is that you're able to identify the true reason for the action and back it up with documentation. Moving on to whistleblower claims. These are a subset of retaliation claims where an employee alleges that he or she suffered an adverse action because of raising concerns about or reporting perceived violations of law. There are three main elements of a whistleblower claim. First, the employee has to have had reasonable cause to believe that a violation of state or federal law has occurred or is occurring. Second, the employee has to have reported the violation to his or her employer or to a federal or state agency, or refused to participate in perceived unlawful activity. And third, the employer has to have retaliated against the employee as a result of the employee's report of the violation. Reasonable cause in this context is an objective standard. So the question is whether an employee has reasonable cause to believe a violation of state or federal law has occurred or is occurring, where a reasonable person with the same training and experience as the employee would believe that the conduct could rise to the level of a violation. With whistleblower claims, it's important to remember that what might be construed as an employee generally complaining about work conditions could be deemed a report of an alleged violation of law. So it's important to pay close attention to the nature of the complaints you're receiving. So COVID-related whistleblower claims. Employees are increasingly raising concerns regarding personal protective equipment, social distancing, and other health and safety measures that their employers may or may not be employing during the pandemic. Specifically, many employees are raising concerns that their employers are not complying with state and federal guidance aimed at preventing the spread of the virus. For example, although OSHA has not implemented any coronavirus-specific workplace safety standards, employers are still required to comply with the existing standards that cover pandemic-related safety risks. Most notably, the Occupational Safe and Healthy Act requires employers to guarantee their employees a workplace that is, quote, free from recognized hazards that are causing or are likely to cause death or serious physical harm. Employees have filed a multitude of complaints relating to that requirement, which typically allege that an unsafe work condition has caused sickness or death due to COVID, or that the employer has failed to take appropriate measures to reduce COVID exposure and spread within the workplace. As an example, employees have filed complaints based on their employer's failure to provide hand washing stations, sanitizers, and masks on location. Claims have also been filed based on the alleged failure to enforce social distancing measures and failure to require masks in areas of the office where exposures increased. Other employees have alleged that they have been unable to practice social distancing due to the location of their workspaces or the nature of their jobs. And finally, we've seen claims based on employers' alleged failure to require and enforce self-quarantine measures following an exposure or potential exposure to the virus. It's worth noting that a common thread in these cases involves the concerned employee, at least allegedly, facing off with a supervisor or executive who responds to the employee's complaint by essentially accusing the employee of overreacting or exaggerating the virus. And in some cases, essentially saying something to the employee like, calm down, this is just the flu. In any event, at the same time as all of these new employee concerns are flowing in, many employers are faced with the reality of changing or reducing hours, cutting pay, terminating employees, and the like due to the widespread decline in business activity. This combination of increased health and safety complaints with the simultaneous escalation of employment actions really creates a perfect storm for whistleblower complaints. So it's unsurprising that we have seen an increase in these types of claims. Okay, so how to avoid COVID-related whistleblower and retaliation claims. In the current environment, in which employees have increasingly raised retaliation claims related to health and safety complaints, employers should be particularly vigilant to enforce anti-retaliation policies and procedures. Some practical considerations include reviewing and updating your company's policies and procedures that prohibit retaliation, and consider setting aside some additional training time now to help your managers and supervisors understand how those policies operate in the context of COVID-related requests and complaints. After that training, you might send out periodic communications to those managers and supervisors, just reminding them to objectively listen when employees request accommodations or raise concerns, and then appropriately refer and escalate those issues consistent with your company's policies and procedures. Frequently, retaliation and whistleblower claims come about based on the actions of managers or supervisors who are just ignorant of the law. So training is really important. Next, take health and safety complaints seriously. There are certainly many differences in opinion regarding the severity of this virus and what is necessary or not necessary to ensure that everyone is safe in the workplace. But no matter where you fall on that spectrum, it's important to make sure that a complaining employee feels heard. Even if you think it's true, it's never a good idea to respond to a complaining employee by accusing him or her of exaggerating the virus. As I mentioned, complaining employees do not take kindly to that sort of response and frequently respond by filing whistleblower complaints. It's important that the employee feels heard and feels that the company will respond to the complaint with care. It helps to create an environment where employees feel encouraged to report health and safety concerns. I would suggest that you create multiple avenues for your employees to raise their concerns, and be sure that those avenues are clearly communicated to your employees, preferably in writing. It's also important to make sure that the specifics of health and safety complaints are appropriately documented, including the time and date, the recipient of the complaint, and the specifics of the concerns that have been raised. If necessary, investigate the concerns that are brought to your attention, and wherever possible, circle back and provide that concerned employee with a summary of the outcome. Next, be sure that there are reasonable, non-discriminatory justifications for your decisions about which employees can and can't work remotely. Where independent reasons justify disciplinary action against an employee who recently raised health or safety concerns or requested an accommodation or otherwise engaged in protected activity, ensure that those reasons are properly documented and that other employees who have engaged in similar conduct received the same disciplinary action. Finally, if you are in the unfortunate position of having to lay off or furlough employees, remember the selection criteria issue that Liz mentioned in the previous presentation. It's important to make sure that you've got neutral factors that dictate the selection of the employees who are impacted by your decision, and that no protected class of individuals is unintentionally impacted more than others. For example, an employee who claims that her position was eliminated because she asked to work remotely as a reasonable accommodation, it's helpful if you can point to the list of eliminated employees and demonstrate that the eliminations were based, for example, on reverse seniority. So that's all I've got for you today. I hope this was helpful, and I'm going to go ahead and turn it over to my colleague, Brian, who's going to talk about year-end compliance.
Thank you, Megan. As Jim mentioned, my name is Brian Bouchard. I'm a litigator here with Sheehan Finney, and I'm also going to be working in the firm's Portsmouth office, which is opening in January of 2021, which we're very excited about. But for now, like a college kid starting a band, I'm in the room above my garage. If you happen to hear leaf blowers in the background, that could be my neighbor, or maybe the quarantine is finally just getting to us all. But for the next 20 minutes or so, we're going to be talking about year-end compliance and 2021 forecasting, to the extent we can forecast anything with the virus right now. So as you'll see, we are really living in the land of the setting sun. The FFCRA sunsets December 31st of this year. Major parts of the CARES Act will also expire at the end of the year, including the Pandemic Unemployment Assistance, which provides unemployment benefits to individuals who traditionally would not qualify under the state program, or maybe even the state doesn't have a program. Also, what's going to expire at the end of the year is the Pandemic Emergency Unemployment Compensation, and that is part of the CARES Act that provides an additional 13 weeks of unemployment benefits to individuals who qualify for unemployment. You may recall that New Hampshire generally has, not generally, it does have 26 weeks of unemployment benefits. So with the Pandemic Emergency Unemployment Compensation, that increases to a total of 39 weeks. Part of the CARES Act that has already expired is the Pandemic Unemployment Compensation, which was that $600 a week that caused a little bit of consternation across the country and across the media at the beginning of the summer, and that expired in July. So before the FFCRA expires, let's talk about some end-of-year compliance and some end-of-year issues. As you may recall, the FFCRA offers a tax credit to employers to offset the cost of providing paid leave. Now, that tax credit is available immediately, and employers were able to take it really as soon as the FFCRA took effect and people started qualifying for leave. If for some reason you haven't been taking the tax credit contemporaneously, don't worry, there's still time to file forms with the IRS to receive a tax credit on the back end. And the tax credit isn't just for the qualifying wages that were paid out under the FFCRA. It also applies to qualified health plan expenses, as well as the employer portion of Medicare tax. Putting the tax credit aside, there are also some end-of-year reporting issues for the FFCRA. As you know, at the end of the year, or the beginning of the following year, employers are required to issue a W-2. This year, there's a specific requirement in Box 14 to report wages that were used under the FFCRA, and there's specific labels that employers have to use, which I put in my slides here. The first is that if leave was taken for paragraphs 1, 2, or 3 of the FFCRA, employers are required to report sick leave subject to the 511 per day limit. Paragraphs 1, 2, and 3, you can look that up in the statute, but just briefly, paragraph 1 was the employee was required to quarantine or go into isolation because of a local, state, or federal order. Paragraph 2, the employee's healthcare provider has advised the employee to go into quarantine. And paragraph 3, the employee was experiencing symptoms associated with COVID-19 and was seeking a diagnosis. With respects to paragraph 4, 5, and 6 of the FFCRA, employers are going to be required to report at the end of the year sick leave wages subject to the 200 per day limit. Again, those paragraphs are outlined in the FFCRA, but just briefly for today's purposes, paragraph 4 was the employee was caring for someone subject to a qualified quarantine. Paragraph 5 was caring for a son or daughter whose school or daycare has closed. And paragraph 6 was substantially similar condition as specified by the U.S. Secretary of Health and Human Services. The best practices here is to begin working with your payroll and tax professionals to get this information together now so it doesn't become a rush come January. Now, as the FFCRA winds down, we have about 6 weeks left. We'll talk a little bit later as to whether the FFCRA may be extended. I think it will, but time will tell as to what Congress does. There's some end-of-year issues that are going to crop up. The first is that the remaining leave under the expanded FMLA is going to be limited. It's not going to be the 10 weeks called for under the FFCRA if someone is just qualifying. And the reason for that is that the statute expires in 6 weeks. And so it's best to manage employee expectations up front and let them know that the statute expires and they only have expanded FMLA leave until the end of the year. That will help avoid issues down the road if in fact the FFCRA is not extended, which I expect it to be, but it's best to address those issues up front. Another issue that's been creeping up and is going to probably creep up more and more as we enter into the second or third surge, excuse me, is what to do with hybrid and remote working. New York just announced yesterday that all its schools are closing and going to remote learning. That could happen in New Hampshire very easily. It could happen in Massachusetts very easily to the extent it already hasn't, or to the extent that someone's son or daughter is not enrolled in a program or a school that's using a hybrid model. So how does the FFCRA, specifically the expanded FMLA leave under the FFCRA, apply? what the USDOL has said is that essentially this, it is going to treat hybrid programs like this. If the school is open, the physical school is open, and the eligible son or daughter is permitted to go into school, then an employee would not otherwise qualify for expanded FMLA leave. And the reason for that is the school is open and the child is able to go into school. So if someone is keeping their child home because of personal reasons, that person will not qualify for FFCRA leave because the school is open and the child is able to go into school. If, however, the school is open, but the child is not permitted to go in on a specific day, some hybrid programs, someone might go in on Tuesdays and Wednesdays or Thursdays and Fridays, then in that situation, even though the physical school is open, the employee would be eligible for FFCRA leaves, provided they meet all the other requirements, because the child isn't actually able to go to school and the parent has to stay home and care for the child so long as there's not another suitable person to do so. Same situation applies for remote learning. Remote learning, the physical school is closed. So under that situation, the USDOL has taken the position that because the physical school is closed, a person would qualify for expanded medical leave so long as they meet the other qualifications. Let's talk about PPP loans and some end of year compliance as well. The PPP loan program closed August 8th, 2020. For this morning's purposes, I'm going to assume that there is not too many questions about what type of expenses qualify for forgiveness under the PPP program. In some respects, we've sort of crossed the Rubicon on that. Many of the funds received under the PPP have already been used, and you can't go back in time and use those funds for qualifying purposes now. What I want to talk about, though, is the process for applying for forgiveness. It's a simple process, but the devil is in the details here. The first step that businesses are going to have to take in applying for PPP forgiveness is to go to the lender that issued the loan. And the lender is then going to help the business hopefully complete the loan, but identify which SBA form the business needs to use. And there's three forms. There's form 3508, and then there's the easy form, and there's the S form, all 3508. The easy form is a short form of the forgiveness application. It's only 3 pages, but it still requires a good amount of detail and a good amount of documentation that the employer has to provide. A business is going to be eligible to use that shorter version of the forgiveness form if the business meets one of these 3 categories. The first is that the business is self-employed and there are no other employees. The second is that the business did not reduce the salaries or wages of its employees by more than 25% and did not reduce the number of hours for employees. And the third qualification that a business might be able to use the shorter easy form is that the business experienced a reduction in business activity as a result of COVID-19, and that business did not reduce the salary or wages of its employees by more than 25%. So if a business meets one of those 3 categories, you can use the easy form, which again is only 3 pages. The S form is also another shorter form of the forgiveness application. And that's available if a borrower received less than $50,000 in PPP loans. Now, the sort of wrinkle there is that if the borrower has many affiliates and all those affiliates, the aggregate of the loans received total more than $2 million, then that loan affiliate, that loan business cannot use the S form. But again, work with your lender. They should be able to help you identify which form to use. Work with your attorney. That attorney should be able to do the same. What you're also going to need to do is start assembling all the documents called for in the SBA form. Those include payroll records, tax records, and sort of what's being called non-payroll records. Those are the business expenses that may have qualified for forgiveness as well, such as mortgage, rent, and utility documents. It's important to note that there is no end of year deadline to applying for forgiveness. Rather, forgiveness just needs to be applied for before the maturity date on the loan. And that's going to be notwithstanding the date stamp on the forgiveness application itself. One caveat, because there's always a caveat, is that the deferral on payments lasts only 10 months from the end of the covered period. So while the business doesn't have to apply for forgiveness until the maturity date of the loan, the deferral on payments on the loan is only going to last for 10 months after the covered period ends. So it's beneficial to apply for forgiveness early. Finally, with respect to PPP, the SBA announced recently that it's going to send or will potentially send loan necessity questionnaires for loans over $2 million, and that's for both the nonprofit and for-profit sector. These questions are meant to get at what the necessity of the loan and whether the business, when asking for the loan and when completing the certifications, made those certifications in good faith. And one of the issues that the SBA is drilling down into is whether the money received under the PPP loan by the business was necessary to support ongoing business operations in light of the economic downturn. Specifically, whether the business at the time the loan was requested and at the time the good faith certification was made, whether the business had access to other sources of liquidity that wouldn't be detrimental for the business to use. If you're a business that gets one of these questionnaires, I encourage you to contact your attorney. The questionnaires have to be completed in 10 days. There's a lot of detail that needs to be covered. And you don't want to run into a situation where your good faith certification is being questioned. So other considerations to think about before we wind up this end of 2020. And that is to calculate employee retention tax credit under the CARES Act. Like the FFCRA credit, this is something that employers could have been taking along the way from March 12th to the end of this year. If you have not been taking a tax credit, I encourage you to explore that with your tax attorney or with your tax professional. It allows businesses a 50% of qualified wages up to $10,000 per attorney in a tax credit. So that can be very beneficial for a business. The other thing to consider before the end of the year is COVID training. New Hampshire requires mandatory training for all employees and volunteers on the universal guidelines that have been promulgated from the governor's office. If you haven't done it yet, do it. There's no end of year requirement with that, but as we're thinking about the end of the year and dotting all the I's and crossing all the T's, it's a good opportunity to do it. The other thing to consider doing before the end of the year is updating your handbooks. This is the season where a lot of businesses update their handbooks. Make sure that when you're updating your handbooks this year, that you include the universal guidelines as part of that analysis. For example, the New Hampshire's universal guidelines require that employers change their policies to be consistent with public health announcements for COVID-19. The universal guidelines also strongly encourage employers to adopt a flexible and non-punitive sick time or sick leave policy that enables employees to miss work without risking their job. As you may recall from the universal guidelines, if an employee is showing symptoms of COVID-19 under the universal guidelines, they are required not to report to work. So this is a good opportunity to update your handbook and ensure that you are complying with the universal guidelines going into 2021, because the universal guidelines are sure to be in effect for the first part of 2021 as well. Finally, well, not finally, but address any health insurance issues that you have now. Specifically, what you want to look into is vaccine. Is the vaccine, which is being manufactured in New Hampshire right now, is that covered by insurance? Is it covered by the employer? How can you eliminate barriers to access for your employees to get a vaccine and get back to work safely and get back to business as usual? And finally, don't forget about performance reviews this year. I've talked to many employers who have kind of put performance reviews to the wayside, saying, oh, well, it's remote work. It's more difficult to gauge an employee's performance. And while that may be true, it's still going to be important going forward to have comprehensive performance and reviews for all your employees. There shouldn't be a gap year. If there are performance issues that need to be addressed, even if it is, a person's not great at working from home, make sure you address those performance issues because while there is, a vaccine on the horizon, we are still going to be working from home for a good period now. So what's on the horizon in terms of bills in Congress here? There are two proposals from Congress and then a White House proposal, which provides as one of the proposals from Congress. So the one from the House is the Health Economic Assistance Liability Protection in Schools Act, the HEALS Act. The highlights from this is that it increases the employee tax credit from 50% to 65% of qualified wages. It offers an additional $30 billion in PPP, but limits the eligibility for businesses. For example, if a business is publicly traded, it would not be eligible for PPP loan, and extends unemployment eligibility for non-traditional individuals and reinstates the $600 per week that we talked about earlier. Competing with that in the Senate is the HEROES Act, which is the Health Economic Recovery Omnibus Solutions Act. And the highlights for that act are this: it increases employee retention tax credit from 50 to 65% as well. This one offers an additional $190 billion in PPP, which is significant. On the flip side, with respect to unemployment benefits, it is much more limited. It offers $200 to $500 per week in federal unemployment benefits, depending on the situation that the employee is in. And the White House plan is a revised version of the HEROES Act. We'll see if the White House plan gets enacted, by January 20th. Okay, so I talked about earlier, whether the FFCRA would be extended. I think it is more likely than not that it will be extended by Congress. For how long, I don't know, but I think it is going to be extended. First, the FFCRA enjoyed, wide bipartisan support in Congress when it was enacted. I think it passed the House by 340 to 60 votes, and it passed the Senate 92 to 8, which is something you don't see that often. Second, there was a study done by the Health Affairs Journal that estimates that the FFCRA reduced COVID cases by 400 plus cases per day by state. To put that differently, it prevented one COVID-19 case per day per every 1,300 workers. So there is some evidence here that the FFCRA has done its job in stemming the tide of COVID-19. And there hasn't been competing evidence that it has been, disastrous economically for businesses in light of the tax credit being offered. If I were to take a guess, I would say that the FFCRA gets extended to July 1st or maybe June 1st, but time will tell as what Congress is going to do. And finally, just some recent changes that was announced last week, or maybe the week before in New Hampshire. There is a new quarantine guidance in New Hampshire for travel. So before traveling internationally by public charter or outside of New England, previously required that a person quarantine for 14 days, even if they were asymptomatic. So you travel outside of New England, when you come back to New England, or if you're traveling outside of New England or coming to New Hampshire, you got to quarantine for 14 days. The new requirement is that a person returning to New Hampshire or arriving in New Hampshire from somewhere outside of New England is that they quarantine for 14 days or quarantine for 7 days plus have a negative COVID test. And so what that's going to look like is you quarantine for 7 days. And then you take a COVID test on the 7th day, which takes 48 hours to get results. So you stay in quarantine for that extra 48 hours. So on the 9th day, if you get a negative result from your COVID test, you are released from quarantine. All right, so trends that are likely to continue into 2021. I think there's going to be an increased focus on safety, certainly under the universal guidelines. Those aren't going anywhere. So if you haven't updated your handbooks, now's the time to do so and address the safety considerations in the universal guidelines and to train your employees on COVID-19 safety. Teleworking accommodations are something that are going to be very likely to continue, specifically in the ADA realm. And I also think that there's probably on the horizon going to be some paid leave acts going through Congress, given the success that FFCRA has had in stemming the tide of COVID-19, but there's going to be some debate as to whether that should continue in a non-pandemic setting. And that's all I have for today, and I think we'll open it up for questions, and thank you for listening.
Liz, do you want to take a stab at looking at some of the questions?
Sure, I see that there are several questions that look like they might be in Brian's wheelhouse, which will give him a few minutes to take a look at since he was just presenting. A couple of things that might touch upon what I had talked about. One question had been, if you have less than 20 employees, which 20 employees triggers the Older Workers Benefit Protection Act, but if you have less than 20 employees, does New Hampshire law have regulations or coverage or protection for those smaller employers along the lines of the Older Worker Benefit Protection Act? The answer is there isn't a similar requirement like the Older Worker Benefit Protection Act for employers with less than 20 employees, but New Hampshire does have a discrimination law of its own, which applies to 6 employees or employers with 6 employees or less or more, excuse me. And that law does have age discrimination protection. So there are discrimination protections that apply. And in addition, it's just good as a matter of fact, if you're having a release of claims, you want it to be understandable, and you want to give the employee a reasonable amount of time to consider it. So those are 2 concepts that are embedded in the Older Worker Benefit Protection Act that can pretty readily apply in general. That would be of help to you under New Hampshire law. Another question looked to be that somebody had said the WARN Act, does it apply during COVID-19? And that person had been told that it does not. The WARN Act does apply, but what may have been relayed to the person asking the question was perhaps under that person's company's circumstances, the unforeseen business circumstances exemption might have applied, and therefore the employer was exempt or accepted from the WARN Act because of that. So we can obviously provide legal advice here that is tailored to people's situations, but in looking at that question, that came to mind that might have been the reason why the person had been informed the WARN Act didn't apply to COVID-19 related layoffs. I know there were a lot of questions coming Brian's way, so I want to give him a chance to answer those if he's had a chance to.
I've read through some of them.
Okay.
Let me go back to where I was here. See if I can find my way back. So one of the first questions from anonymous attendee is, can the tax credit for the FFCRA be used simultaneously with PPP? And the answer is no. There was regulations issued by the SBA, I think in July, although don't quote me on that. But the upshot was this, and that the FFCRA wages do not qualify as forgivable wages for PPP purposes. So while you can, still have employees going out on FFCRA and receive PPP money, you just can't have the wages being used for FFCRA purposes qualify as forgivable wages under the PPP program. I forgot to mention during my presentation that on the question of loan necessity questionnaires, there was an excellent article written by our colleagues at Sheehan, Paul Royland and Colleen Lyons wrote an article. It's on our COVID website. So if you have additional questions on that wasn't covered in my presentation, I encourage you to consult that. Other questions, to clarify, if an employee received wages for childcare being closed due to COVID-19, it has to be on the employee's W-2. And the answer to that is yes, it has to be reported in box 14 on the W-2. I think I glanced over this in my presentation, but wages used for expanded FMLA purposes, the employer is required to report the total wages used and use the following label for those wages, which is emergency family leave wages. Your payroll professionals should be able to assist you in making those reporting obligations. me see here. Megan or Liz, are there other questions, or is this all?
So I'll jump in and just say it looks like we have a pretty savvy group when it comes to retaliation and whistleblower claims, because I don't see any questions related to those. But if any of you think of questions after this is over, please feel free to email me. You can find my email address on the website. And then the one thing that I'll add to my presentation, I mentioned that OSHA does not have any legally enforceable standards in terms of safety in the workplace, but they have issued some guidance, which is called Guidance on Preparing Workplaces for COVID-19. So if you're not familiar with that, it's pretty easy. If you Google, you can find it, and that can give some additional information on what is appropriate to be doing in the workplace to ensure that all of your employees are safe.
One question that was asked with respect to New Hampshire's new universal guidelines on quarantining after travel is whether it's a COVID test or a regular COVID test. Excuse me, whether it's a regular COVID test or a rapid test. It is not the rapid test. It is it's in my slides, it's the SARS-CoV-2 test, and that takes typically 48 hours to process.
It looks like there is another question, as Brian has a chance to digest the questions coming his way, that related to what happens if an employee has exhausted their FFCRA leave and still can't come to work due to childcare issues, the school closure issues. I think at that point, it is good to not forget to look to your existing policies or look to your state law requirements, which either one of them might provide some additional basis for the employee to be out of work, to be on some sort of protected leave, or have some protected ability to be out of work to address those issues. So just because the FFCRA may be exhausted, including if it is for an issue of the paid sick leave, it's great not to just think that's the end of the road, but to look into what is possible, what could be a requirement under your state law or under regular ADA issues for serious, for health issues, if it were paid sick leave. Just keep in mind that the FFCRA doesn't operate in a vacuum. So you just don't want to lose sight of your own policies or the applicable federal or state laws that might apply to the situation. And I really encourage people to take each individual situation and really look at it on an individualized basis, because you may find that there are avenues for that person to remain out of work and to be on some form of protected leave that might not apply to a colleague that has a similar situation.
Someone asked, is there a likelihood that the virus vaccine being mandatory? I don't know the answer to that. I would say that in the healthcare industry, Amy, as you pointed out, the answer is probably yes, but for a religious exemption, which is, I think as soon as a vaccine does come out and we look at whether it's going to be mandatory across certain industries or not, well, we'll likely have another presentation on Title VII accommodations for religious accommodations.
One question was, if you set up a separate COVID policy, do the universal guidelines still need to be added to the handbook? And what I would suggest is, if you addressed the COVID-19 considerations in whatever your state's universal guidelines entail, and you have a standalone policy, it would probably take very little effort to just get out a notice indicating that that standalone policy is incorporated into the handbook by reference. And that way, I think you no question, but that you satisfy your both requirements. If there's a handbook requirement you can have that policy be a standalone policy, but yet cross-reference it to the handbook. And we do recognize, as Brian said, that sometimes year end or beginning of the year, there's a real effort to try to dust off your handbooks and make some good changes. This is a great opportunity to be doing that with some of these guidances and guidelines. But certainly, if you have standalone policies, I think there's probably some pretty easy fixes as to how they could be incorporated in your existing handbooks.
One question is, are municipalities also required to report the wages paid pursuant to FFCRA leave on the W-2, given that you don't take a tax credit? That's a good question. I'm not aware of any exemption for municipalities to report the wages used on the W-2. My read on this is that even though there's not a tax credit available, you are still required to report the wages used for FFCRA. But I'm not aware of any exemption, which makes me think that there isn't one. It's not one I came across anyway.
One question, great question, was if an employee has already used a COVID leave under the FFCRA, can they use it multiple times? And I think the great lawyer answer is it depends. There's no prohibition from somebody using FFCRA leave for multiple times. It could be, unfortunately, that is needed. But what there is under that act is that there is a cap on the time available for people to use their FFCRA leave. So for instance, if you're a full-time employee, there's a cap of 80 hours for the paid sick leave. And it's important, again, to treat each individual situation as an individual situation and track the use of the paid sick leave or the extended family medical leave. But the reality is that there are caps in terms of how much time can be used. And if the employee hasn't gone through the capped amount of time and they have another qualifying reason that occurs, then they would still have FFCRA leave available to them, even though they're using it more than once. So it's important to keep track of that time used and not make an assumption that somebody doesn't have it more FFCRA leave available to them. As a practical matter, the time is getting near here towards the end of the year. So as Brian said, great idea to just keep employees aware that that we're coming close on December 31st.
Another question that popped up here is, can you please comment further on the mandatory training for employees in the state of New Hampshire per the universal guidelines, which I pulled up on my screen, so I'm looking away. What the guidelines say is that you're required to provide training to your employees on the universal guidelines themselves, which include requirements about cleaning, disinfectant, about the virus itself, and about protocols that employees need to be taking before reporting to work, such as temperature taking and the like. Employers are also required to provide training to their employees on specific industry guidance that's been promulgated by the governor's office. So if you're in the restaurant industry, for instance, there's certain protocols that employees need to follow in order to maintain a safe environment. You're required to provide training on those specific industry protocols as well. There's no timeline listed in the universal guidelines for accomplishing the training. The guidelines just say that training is required. So it's a good time of year to wrap up things like that and handbook work as well.
There was one good question about, Brian had touched upon the new aspect of the universal guidelines about the 7-day quarantine testing protocol. And the person said, gee, I just looked last week and I didn't see this. It probably, you barely missed it, would be my answer to that. And if you look at the universal guidelines now, you will see it discussed in the helpful chart amongst other places, but discussed in the helpful chart that you see it, I think, I want to say about page 5 of the universal guidelines. So the person asking the question probably missed it by very little. And you know, these guidelines do evolve pretty quickly and sometimes with more notice than others.
Okay.
I want to thank our presenters this morning, Liz Bailey, Megan Carrier, and Brian Bouchard for being a part of this part 2 of the reboot of our labor and employment seminar. I think it was a terrific program and lots of very useful and timely information. And so just to remind you folks that the program has been recorded, the slides will be available and the audio will be available on our website. If you have additional questions, as Megan said, you can reach out to Megan, Liz, or Brian separately. You've got their contact information on this last slide. And HRCI information is also available on this slide deck. So thank you so much for being a part of this today. Wishing you all the very best in truly challenging times. And please stay in touch with our website to see about upcoming programs, either through the High Tech Council or otherwise through She and Finney. So thanks so much. Thanks to our presenters again. Great program, and look forward to staying in touch with you folks.